Brian specialises in defending complex and sensitive employment law litigation on behalf of insurers and their insureds as the key element of the senior roles he has held at leading national and global commercial law firms over the past 20 years. So with that, over to you, and thanks for joining us, Brian, today.
Oh, thank you, and good morning to everyone. Thank you very much, Sarah. So I'm going to be speaking about mandatory vaccinations in Australia and some of the legal issues and some of the key topical issues. I intend to speak for probably about 30 minutes or so thereabouts, depending on how we go, which will leave time for some questions. So let's jump right in. Can I have the next slide, please? So this slide just sets out the vaccination rates. It's a couple of days old now. So the actual rate that I just checked 3 minutes ago is 83.9% of Australians aged 16 and over are fully vaccinated. If you look at the right side of that slide, you'll see that WA and Queensland are a little bit behind. I'm in Perth, so we're amongst the behind lot. But Victoria and New South Wales are speeding ahead, and I note that Victoria looks as though that it will reach 90% by the 23rd of November. So the rates are significantly increasing, and part of that is certainly as a result of the vaccine mandates and just a general drive within Australia to increase vaccination targets. We're also doing very well in the OECD, much improved over the last couple of months. Can I have the next slide, please? So this is probably the most important slide of the presentation. So I'm going to go through this slide in some detail. So and this covers the entire country. There are 3 circumstances in which an employer may require an employee to be vaccinated and to provide proof thereof. The first and probably the most important one is where required by law or a public health order. But there are public health orders across the country, and they've created certainly some controversy. They do vary between states and territories and are updated from time to time. In general, the PHOs require workers to have received both doses of the vaccine by specific dates, provide information and evidence to the employer of that, and failing which the worker is not permitted on site unless an exemption applies. There are also multiple tiers, usually depending on the nature of the work that's carried out and the relevant risks. I want to say a couple of things about the exemptions because they are that's caused a lot of issues in my practice over the last couple of weeks and months. The first is that the orders provide for fairly limited exemptions based on medical grounds, and it's not sufficient just to have your doctor to say, the employee to have their doctor, provide a certificate or an exemption. The exemptions must be obtained from the Australian Immunisation Register using their specific IM011 form. That's completed by a specialist medical practitioner and submitted to the Australian Immunisation Register for assessment. So it's got to be pretty high levels issues. One issue that I encountered for an employee client a few days ago was they'd had an anaphylactic reaction, and that was certainly fell within the exemption. I'm going to come to some of the cases in a little while, but I also want to look in terms of PHOs around what the consequences are, because there's been some muddle about this, and that is that from the dates specified in the PHOs, without an exemption, an employee cannot access the workplace. And it's also an offence. This is another thing that's been somewhat missing. It's an offence to fail to comply with the direction without a reasonable excuse, punishable by a fine of up to $20,000 on the employer. That's the West Australian position. We've got public health orders around the country. So some of this is a little bit West Australian centric. So I apologise to people who are outside of Western Australia. Then the next part of that PHO that's really important is that each employer or person in charge of the workplace needs to ensure that employees are vaccinated. and requirements are generally placed on the employee in terms of complying with that. And employers need to keep records. This is another aspect of the PHOs that haven't probably been as well understood. Employers need to keep records, including copies of the evidence of vaccination, and ensure unvaccinated staff are not permitted to work. So you need to have the records. Generally, that's it'll click on the mobile phone, which the little passport document or whatever it's called. That's generally issued under the MyGov website, and it's an offence for a person to fail without reasonable excuse to comply with any of these directions. So that they're pretty mandatory. Well, they're mandatory, but they're quite prescriptive in a number of different elements. So that's the PHOs, and I'll come to the West Australian position on the PHOs in a minute. But in terms of the other three circumstances in which an employer may require vaccination, is second of all, where a contract or policy or agreement includes provisions requiring vaccination. Some employers that I advised a couple of months ago looked at this and reviewed their contracts. And then thirdly is where it is lawful and reasonable to give a direction to be vaccinated. And I'm going to come to that in a little bit more detail in a minute. So can I have the next slide, please? And we've got the nice shading here where it sort of phases in. Again, I can't cover mandates throughout the country. There's just too many, but this is the West Australian mandate. And so there were a bunch done in October. There were also healthcare mandates done in September. As you can see from this slide, we had our FIFO mandate, 5th of October. So people who wanted to access employees on mine sites in Western Australia needed to have their first dose by 1st of December and fully vaccinated by 1st of January 22. So a lot of these mandates are actually clicking in terms of the deadlines now or short, very soon. And then we had the sort of the statewide and the broad ranging mandate on the 20th of October. We had the Group 1 and Group 2 industries and workforces set out in that slide, and you can see that the first group is industries determined to have a high transmission risk, and the second one was industries and workforce deemed critical to ongoing delivery. In this state, it's been referred to as the orange sheet. So the orange sheet identifies key occupations and industries. You need to go through those mandates fairly carefully. And as I say, those mandates have really been adopted throughout the country, Victoria and New South Wales some time ago already. So could I have the next slide, please? As you know, as people would know, there's been a lot of questions. Oh, are these mandates lawful? Are they, are they real? Are they, what's the situation? So there was on 15th of October, only a month ago, the New South Wales Supreme Court, a single judge at this stage in Kassam versus Hazard, found that the government had power to mandate vaccinations in accordance with these public health orders. And it was not the court's function to determine the merits of the exercise of the power by the minister. They also said that one of the big issues here has been whether what's known as the right to bodily integrity, in the sense that the person has the ultimate choice as to whether they want to be vaccinated or not. The New South Wales Supreme Court said that right was not violated by the public health orders, in that ultimately it's a decision of the relevant employee whether to have the vaccine. It's their choice, but there are consequences for not doing so. And also the court found that the public health orders don't breach the laws that I've identified in this slide: the Privacy Act, federal discrimination laws, the Australian Immunisation Register Act 2015, and the common law right, the common law right to vote. Can I have the next slide, please? So let's talk a little bit about lawful and reasonable directions, because that's, if you remember from a couple of slides ago, if there's no PHO, then the question is the direction to be vaccinated lawful and reasonable? So you only really needed to consider this, as I've said in this slide, if there's no PHO. But then the question becomes, if there's no PHO, and that covers a significant proportion of people, so close to 45, 50%, depending on states and the particular PHO. But the question, therefore, that needs to be considered at common law is whether the direction to vaccinate or the requirement to vaccinate is lawful and reasonable. So the question of lawfulness is described is a question of by reference to legislation, contract, award, or agreement, and the question there will be whether it's unlawful. And generally, most directions in the current environment would likely be considered lawful. The question, though, is generally the question of reasonable is one of reasonableness. So in terms of reasonableness, as I said in the third dot point, you need to look at, in considering that, you need to look at specific workplace circumstances. So the fact that the pandemic is not enough. So the Fair Work Ombudsman have provided some guidance as to what sort of matters are likely to be relate to this question of reasonableness. There is some element of grey here, but some of the factors are the nature of the particular workforce, and in particular, the extent to which employees are in public-facing roles, and whether social distancing is possible. So certainly, if the person is working from home, some people work from home exclusively, that's going to make it more difficult to assert that the direction to vaccinate is reasonable. The extent of community transmission at the time. So that's been an interesting, I suppose, comparison between the eastern states and here in Western Australia. So in Western Australia, we've had no cases. So the direction, the question of reasonableness, it's certainly been understood that it's less reasonable to direct vaccination where there are a lower level of cases. The terms of any public health order, the risks associated with the work. So if there are vulnerable people who you might be interacting with, the vaccination direction is more likely to be reasonable, medical reasons, etc. So certainly, I think it's a fair thing to say that as we've had increased cases and certainly increased vaccination, and we've tipped over, as it were, to a much higher vaccination rate. I think that reasonable, it's certainly been the view that reasonableness, it's more reasonable to enforce a vaccination direction. Can I have the next slide, please? So I want to look in a little bit of detail and perhaps give some context to what I've just said in a sort of a practical example, and that's the decision in Kimber versus Sapphire Coast Community Aged Care Ltd. We haven't had a lot of cases in the Fair Work Commission and other jurisdictions on the COVID vaccine, but we did have this applied for flu vaccines, and this Kimber decision was a flu vaccine case, although the full bench of the Fair Work Commission made some comments about COVID, which I think are clearly relevant. So what happened here was that Sapphire dismissed Mr. Kimber, who was a receptionist in one of the aged care facilities, after Ms. Kimber refused to receive an influenza vaccination in 2020. There were public health orders issued by the New South Wales government regarding taking flu vaccinations in 2020. And under that public health order, employees were not permitted to enter aged care facilities unless they'd had an up-to-date vaccination. Sapphire complied with this order by directing and ensuring that any employees who did not have a flu vax were not permitted to work at its aged care facilities. And a number of employees were dismissed as a result. Ms. Kimber She claimed that she developed a severe skin inflammation in response to a flu vaccine she'd received in 2016, so a couple of years ago. She produced a doctor's certificate stating that she had a medical contraindication to influenza vaccines. However, Sapphire did not accept this on the basis that severe facial swelling and rash lasting 10 months from a vaccine was not a medical contraindication for the influenza vaccine, and therefore she was not exempt from the government mandate. And before the Fair Work Commission, Sapphire Coast community produced expert medical evidence, which concluded that it was improbable that the skin condition was caused by the influenza vaccine. So there was a fair bit of evidence of that, and there was, extensive discussion of this notion of this direction. So we had a split decision. So we had of the full bench, we had Vice President Hatcher and Commissioner Rawdon, and they said that the dismissal was fair and lawful, and they made a number of key comments. I want to pick up on a couple of them because I think they're quite useful guides on where we're going to head, where the current law is, and also probably where we're headed in the future. So the full bench said that this, as I said, was a flu vaccination case, but the full bench made quite a few comments about COVID-19 vaccinations and public health orders in that context. So what they said was that because there was a public health order requiring the employees in aged care facilities to have a flu vax, therefore an employee who did not do so was unable to perform the inherent requirements of their position, and that employers were justified in terminating the employment in such a circumstance. So the test therefore became this notion of the inherent requirements of the role. And certainly because of the public health order mandated the flu vax, therefore it became part of the inherent requirements of the role. Now, they also, the majority also made some comments about medical conditions and said that where a medical practitioner fills in a medical contraindication form, there must be a widely recognised medical basis for the practitioner asserting that the patient has a contraindication. Because Mrs. Kimber had said that she'd obtained a letter from a practitioner of Chinese medicine, and that the majority held that Ms. Kimber's letter from that practitioner of herbal Chinese medicine was also plainly not based on medical science, and the reference to an ancient formula of herbs being used to prevent COVID-19 and to achieve a healthy herd immunity was sufficient evidence of this. So they made the comment that they discouraged the proposition that a treating doctor is permitted carte blanche to fill in any medical condition as being a medical contraindication. So as I've said, the circumstance that I encountered a couple of days ago with a client who'd had a anaphylactic reaction to the vaccine. She'd her throat had constricted, mouth had constricted, couldn't breathe, and she had to have urgent medical treatment. That's a standard contraindication in the vaccine scenario. So they found, the majority found, as I've said in this slide, that the termination of the employment for failure to take the flu vaccine was not unfair. I want to look at the minority for a moment, because the minority made some fairly strident views that have been criticised by other courts in an open sort of forum. But the minority Deputy President Dean said that she had never more strenuously disagreed with an outcome in an unfair dismissal application, and that the majority denied Ms. Kimber the protections afforded by the Fair Work Act, in part because of an inference that she holds a general anti-vaccination position. And she said this, and this is, I think, stoked a lot of the debate. She said that all Australians should vigorously oppose the introduction of a system of medical apartheid and segregation in Australia. It is an abhorrent concept and is morally and ethically wrong, and the antithesis of our democratic way of life and everything we value. So that sort of language, I've got to say, is fairly unusual for a judicial officer, but she made that proposition. She also found that, and it's you know, again, this has stoked some of the debate, that these mandatory vaccination directions are a lazy and fundamentally flawed approach to risk management and should be soundly rejected by courts when challenged. I make the proposition that I think Deputy President Dean's dissenting decision appears to be somewhat inconsistent with the position adopted by state and federal and territory governments, and the comments that I made earlier in the New South Wales court about this. So, and the minority, Deputy President Dean, found that COVID-19 vaccination themselves have only been provisionally approved for use in Australia, and that they're still part of a clinical trial. But again, that is the minority view. The majority view found that the termination of the employment for failure to take the flu vaccine was not unfair. And that, combined with the comments that I made earlier from the Supreme Court of New South Wales, would certainly seem to suggest that they are lawful, and that employees are going to have real difficulty in opposing them unless there's some serious medical contraindication. We're still at a relatively early stage, but that's clearly the issue. And certainly employers have taken the view that they're 100% bound by them. And I think that's probably the correct position at this point in time. Could I have the next slide, please? So, you know, that's the decision in Kimber. It does follow a couple of other earlier decisions, but that's the full bench decision. You know, on balance, that's probably where it's headed. So a couple of practical suggestions, and then I'll take some questions, because I've seen a lot of questions already that have come up on, you know, even pre the presentation. So obviously, there are significant occupational health and safety risks involved here. And one of the questions that I've been asked is, what about prospective employees? Can as part of the interview process, employers request or require employees to provide evidence of vaccination? That is the Fair Work Ombudsman's guidance note is probably a little bit less detailed in that area, but I think the position, in my view, is quite clear that if there's a public health order, that means that employees who are unvaccinated cannot come onto site within those deadlines. So that clearly means that if there is a public health order, I think there's absolutely no reason why an employer cannot ask, and they should ask, you know, whether the prospective employee has been vaccinated. And any decision not to employ on that basis, you know, the risk of a general protections claim in that regard, I think would have very strong grounds to defend that on the basis that you're simply acting in accordance with the law, in accordance with the Fair Work Act generally. So again, the points I've made in this slide, the mandate workers return to the office need to be vaccinated, and you know, employers in accordance with occupational health and safety risks can request vaccination status information from employees. Just if I can just take one step back and perhaps add, employees who are not within PHOs, I think that you know, in terms of reasonable directions, I think they can certainly request vaccination status. Again, that's going to be a question of reasonableness, and I've dealt with that in a bit of detail earlier on. Can I have the next slide, please? So the next slide really covers a lot of media traffic, frankly, on questions of discrimination. Is it discriminatory to employ someone or terminate their employment on the grounds that they haven't been vaccinated? So equal opportunity legislation, this in very general terms, equal opportunity legislation, both at the state and federal level, prohibits unfavourable treatment on account of a protected attribute. This includes indirect discrimination. So, indirect discrimination is where a criteria is applied, and if a person doesn't have that criterion, whether they might be gendered, but in this context, vaccine status, that's the relevant criteria. So, and a medical condition is a protected attribute under the Fair Work Act, medical disability. But the problem that I think employees face in terms of discrimination claims is that the Fair Work Act and other legislation provide for an exception where the employee is unable to fulfil the inherent requirements of the position. And if there is a PHO, then being vaccinated will be an inherent requirement of the position. And it might even be argued that even where there's no PHO, that being vaccinated may be an inherent requirement of the position. And in that case, I think there are fairly limited grounds for arguments about discrimination. We're probably yet to see that come out. There haven't been any decisions yet. And certainly I think, and I'm going to come to that in the next slide, but looking at reasonable accommodations around working from home, etc. I'm going to come to that perhaps on the next slide. Political or religious belief, I've been asked an enormous amount of questions, frankly, about that. And one of the issues has been people who object on the grounds that the vaccines in the United States and Britain were prepared or developed as a result of stem cells, and that's become a big call and cry. I'm not actually sure whether that's actually strictly speaking correct, but certainly the political and religious beliefs has been a difficult criteria to suggest that would avoid a PHO. And in terms of the PHOs, I think that they're reasonably bulletproof at this point in time. I've put it on the last dot point, other claims there, because I think that we're still to a certain extent, the claims are still emerging. So that's in terms of discrimination. I think there are limited options, particularly because of that notion of inability to fulfil the inherent requirements of the position at law. So can I have the next slide, please? So this is probably one of the most important slides in the presentation. I think the question that keeps coming up is, what do you do when people are not being, they refuse to be vaccinated? So this is a bit of a menu, if you like, of options. And look, this has been something that a lot of employers have had to wrestle with. I think the starting point is to really look at options that give options in terms of retaining the person within the workplace. Alternate work arrangements is really the principal one of those. And can the employee perform alternate duties that allow work from home? That's certainly been a very strong option, but it's limited, a lot of roles simply don't allow that. Some do, certainly in an office environment. The predominant option has been granting annual long service leave until the employee is able to be vaccinated. Really a pause in the process, and that's been extensively used. And it's the idea, I think, is to give the employee the option to sort of to really consider being vaccinated. But we seem to equally have this stand down, the third dot point, and that's been going, there's been quite the periods are likely to be long, and if people are refusing to be vaccinated, that certainly creates that issue. And I think, again, the fundamental problem, I think, is, certainly in the last couple of weeks, has been that, and speaking to employees, is how to deal with the public health orders. And last of all, obviously employees have been terminated for failing to obey a lawful and reasonable direction. I've referred in that slide to immediate termination, but employers need to look at options around notice, providing payment in lieu of notice, and then there are risks of that. But given the decision in Kimber, it is the majority. But there's still some level of risk there. We've seen a lot of stand downs and a lot of people taking leave. And certainly in this state in West Australia, because a lot of those vaccine mandates are really starting on the 1st of December, and some are 31st of December, we're certainly seeing a lot more stand downs and leave. So look, that's a menu. It's a difficult time, frankly. I think most people would agree with that. And a lot of employers are taking the view that, well, look, it's not us that is saying this. It's these government mandates, the PHOs. That's where we're headed with unvaccinated workers, and that's likely to be an issue for months going forward. There's been a lot of public debate, but I'm going to stay away from that because ultimately this is a legal presentation. Could I have the next slide, please? So key actions for employers. A lot of this will not come as a great surprise, but I'm going to go through what I think are some of the key actions in this and the next slide, and perhaps some suggestions about how this might be done in the best way possible. Obviously, the first dot point there, monitoring public health orders and announcements, that goes without saying, and make sure you comply with them. Obviously, as is occupational health and safety risks, and that's clearly a significant issue, and I think it's increasingly an issue in terms of clients, customers, people going for haircuts, makeup, everything. Ultimately there are clearly potential risks of breaches of health and safety legislation if clients get COVID, and I think increasingly we're seeing this two-track economy that that people can only access certain services or go to rock concerts, footy games, cricket matches only if they've been vaccinated. Ultimately there are occupational health and safety obligations across the board. Securely collecting vaccine information. I think the fourth dot point there is really important, and I've encouraged clients to look at time off for attending vaccination, facilitating access to vaccination centres. We might even see vaccinations within workplaces that are much, having someone come to the workplace. I think the key here ultimately, and I think this has been lost, is we're dealing with human beings here, and I think taking a respectful and respectful and pro-employee approach to encourage vaccination is the key. We can't force vaccination, as you know, but there are obvious consequences there for employees. So the next slide, please. A lot of my clients prepared policies, and I recommended that over the last few months, which really provided, I think, a useful way on a granular level to try and make sure that deadlines were set, this was published, and that was something that was really important. I think it's really important also just to try and encourage employees to have the vaccine sooner, because to book their vaccines because of queues. It's become somewhat of an issue, although a lot of people can get vaccinations without much of a wait time at the moment. And then obviously instituting stand downs and dismissals as required. I've left quite a bit of time for questions, but that's in essence the presentation. It's a difficult time, but I think proactive, being proactive and respectful are some of the keys. But I'm going to open up to some questions now. I had a couple of questions earlier in terms of prospective employees, and I've tried to answer that already. So, Sarah, go for it.
Right. Okay. There's a lot. This is from Anonymous. Is just seeing the vaccination certificate on a person's phone and recording that enough?
Yes.
Okay.
Yeah, the answer to that is yes. I think that's probably the best option. I think the best way of doing it. I think the MyGov record, I've got it on my phone. I think it's quite simple, and the best way of doing it is just sending a screenshot and emailing it to your manager. I think that's that is the best way of doing it.
The next one, it's fairly long. It's understood that part of the reasonableness test is to consider local disease transmission, but what about consideration of the future forecast? We're being told that cases will increase as states reopen, but we need to act in advance of that in order to be ready. So in certain circumstances, we're making judgments where there is no community transmission occurring. Can you advise?
Yes, good question. I think that's right. And I think that the factor of low community transmission is clearly a factor, but I think relatively speaking, it is a lower level factor because of the point that you made. So certainly in Western Australia, because we have no cases, but we're likely to get cases at some stage, probably in the new year. You're right. I mean, the reality is we can't avoid it. So I think it's probably a lower level factor. I think the factors that are really key are if there's a medical contraindication, vulnerable employees. These are some of the other factors. It's always going to be a balancing test, the question of reasonableness. And I think employers have taken the view that on the side of caution now, whereas that wasn't the case 8 or 9 months ago. But yes, you're right. I mean, the fact that we're likely to have cases, it's probably that's clearly a relevant criterion. Next question.
Anonymous would like a bit more explanation around how a vaccine could be considered an inherent requirement of the role.
Well, I think that when the PHO says so, that it legally becomes an inherent requirement of the role. I think that's what the full bench in Kimber said. They said that the moment you have a PHO, you have a legal requirement to vaccinate. Therefore, it's as if that is an inherent requirement of that particular role within that location. So if there's for example, there was a PHO, to use the most stark example, the first Western Australian mandate was in the health industry, and the first example, the first tier of that was people working in ICUs. By having a public health order requiring people working in ICUs to have the vaccination, that it became an inherent requirement that if you work in ICUs, it's an inherent requirement that you are vaccinated. Simple as that.
Lorraine asks, in WA, is there any further clarity on manufacturing companies fitting in Group 2 or the lockdown category?
It's hard for me to answer the specific questions on the green sheet, but I'll try. Just manufacturing. look, you have to, you have to look quite carefully at the orange sheet, and perhaps if you want me to give you some specific advice, I'm more than happy to. Well, you need to look at the different criteria in here about critical infrastructure, commercial transport. It might not be covered. It might not be covered, but that it needs a very careful look. But perhaps that's a question that you can email me, or we can have a discussion separately about it. There isn't a specific manufacturing dot point in the orange document, but certainly I can provide some specific advice about that. We've got a lot more. Do we go for it, Sarah?
In Queensland, this is from Anonymous, I thought a public health order had to be issued to an individual by a court. How does a blanket PHO apply when the majority of the population are not showing signs?
I'm not sure I quite understand that question. I mean, the PHO is a direction to people within specific occupations to be vaccinated. That instrument becomes the basis upon which the mandate applies. Perhaps just repeat the question.
As in Queensland, he thought a public health order had to be issued to an individual by a court. How does a blanket PHO apply when the majority of the population are not showing signs? I think we can move on if we...
Yeah, I think so.
Yeah. All right. So this one also, Chris asks, some businesses are designated by federal government as critical infrastructure. Is this a reasonable argument to mandate on their sites?
I think you need you need to read the relevant mandates, the relevant public health orders. I think you need to, in order to make the assessment as to whether the PHO applies, you need to read what it says. So if it's a critical, if there are high transmission or vulnerable risk scenario, you just need to read the mandate. And the question is, does the occupation or industry fall within the mandate? That's the question. It's no more complicated than that. I think it's just a question each time of just reading the mandate. Next question, Sarah.
Tracy asks, within the Fair Work Ombudsman's position, the 4 tiers give some guidance around reasonableness.
Slow down a little bit. It's a little bit hard to hear. Say that again.
Within the Fair Work Ombudsman's position, the 4 tiers give some guidance around reasonableness. My question relates to tier 3. Should the reasonable test around being reasonable to return to office if low community infection is sufficient to be above the mandate?
Again, that's a very detailed question. Let me have a look at the.
They did add, particularly if the role has no customer contact and can work alone in an office.
That's I can't answer a question of that specificity. I just can't. I need to review the. I'd need to review the different tiers and the mandates. But look, perhaps we'll just that might be a good segue into the next slide.
All right, well, I'll go on to the next question. Do you want me to move to the next slide?
Well, I was just going to say the next slide is just the plug, Sarah.
We'll put that. Let me go to the. All right. Yeah, we'll leave that up.
So look, this is just a very quick plug. I've been advising on the mandate for a couple of months. So I've put in place a fixed term arrangement for clients for basic advice, $1,500, which is 3 to 4 hours per matter, reviewing the relevant vaccination mandate compliance issues, reviewing contracts, policy documents, and strategic advice. So some of, it's a little bit hard sometimes to advise on very detailed matters, but that's sort of a fixed price arrangement that I've put in place for a number of my clients. And my contact details are on the presentation. And happy to speak to anyone around the country on specific and granular questions. But I can take a couple more, Sarah.
Okay, so Anonymous asks, how is the mandate enforceable and what happens when the state of emergency powers end?
Well, look, the PHOs won't necessarily last in a sense forever, but they are enforceable under law. It's something that people have forgotten about. They're made pursuant to state legislation. So in this state in West Australia, they're made pursuant to the Public Health Act. But no doubt they won't last forever, and they will be reviewed at some point in time. Certainly, but certainly over the next few months, that they are in place. The New South Wales Court has said they're enforceable. That they are made pursuant to law. So at this stage, they are in play. There's some prospects of them being reviewed at a later point in time. In the next few months, potentially, that's to a certain extent up in the air. Maybe one more, Sarah? One or two more?
Courtney's asked, does emailing the certificate breach health privacy laws? Many medical practices will not use email for this reason.
I don't think it does. The Privacy Commissioner put out a document, Vaccination and My Privacy Rights as an Individual, regarding disclosing my vaccination status. That states that your employer may be able to require you to disclose information about your vaccination status without consent if the collection of this information is required or authorised by an Australian law. This includes any act of the Commonwealth of the state or territory or regulations or any other instrument made under an act, including public health orders or directions. Look, you could certainly just cite the document, cite the certificate. I can't see any particular legal reason why an employer can't obtain a copy of the record. I don't see anything in the privacy document that was put out by the Privacy Commissioner about that. So I think the key is just to know to have a record that the person's been vaccinated. Maybe one more, Sarah?
There is a lot of information online pertaining to fraudulent vaccination certificates. What is the employer's responsibility here, and what should they do if they suspect a fraudulent certificate has been provided?
I think that I think the starting point is making sure that you check. As I said before, checking and obtaining a copy. I think that if you're in doubt, I think that, and there have been a couple of them, I think if you're in doubt, I think you need to report it. I think you need to report it to the relevant health department. We've seen a couple of prosecutions in this state, and I think fundamentally, both in terms of we don't want this sort of thing to continue. So I think if you're in doubt, I think there'd be an obligation to report it. Sarah? Okay,
well, I think we will, there's a lot of questions. I'm going to send you all these questions after. I just think, maybe it might form part of an article that addresses some of the questions that people are raising, because there are just so many. I am going to drop a link in the chat also, because we are a health and safety platform for reporting, and we obviously have a vaccine register that simplifies that process. So there's a form on there if you want to get a quote for that from Myosh. And is there anything else, Brian, you want to add?
Oh, look, there's a lot of information out there. There's a huge amount of information out there about this topic. it's dominating the airwaves. I think the starting point is, you know, you should start with what is in the material that's been provided by the Fair Work Ombudsman, the Privacy Commissioner, and then get legal advice. I think that it's such a difficult situation, and it's such a hot topic in terms of, you know, employees continuing and the risks of claims. I think that obtaining advice is really important. And again, there are significant fines for breaching the PHOs. So, you know, check out check out the relevant stuff on the web, on the government web pages, not other web pages, and obtain advice. You know, I think the other point is think about people's dignity and respect, etc. in that context. But look, thank you for that. More than happy to do some more questions over the chat or in writing. So thanks very much, Sarah, and thanks for Myosh for hosting me.
Yeah, thanks for joining us today, Brian. I will also download the chat because we didn't get to that. There's a lot of comments in there. I might actually put them on the webpage later as well. So thanks everyone for joining us. Thank you once again, Brian, and I will share this recording later today. Thank you.